and welcome back to another edition of Military Witnesses to UAP. If you're not a subscriber to Thomas Fessler's channel, make sure you do that. You subscribe. The link is down below. So a few nights ago, Thomas Fessler interviewed Elizondo, Sean Cahill, and Danny Sheehan. I believe it was March 11th. A little background on Danny Sheehan. He has a long history of contributions to our country, dealing with issues to our nation's Constitution. He's been involved in Watergate, the Pentagon Papers, Silkwood Files, and of course, Colonel Oliver North. Okay, the first question of the night came from Thomas. What the legal avenues and opportunities available to us that could bring a landmark case against the government? When the government of the United States was set up by the Constitution in 1789 and then followed up by the Bill of Rights in 1791, it preserved for the federal government the right for sovereign immunity. They have insisted that the government could not be sued itself unless the Congress passes a particular statute, which is called the Federal Tort Claims Act. The Federal Tort Claims Act lists their total sovereignty immunity to a limited degree, which allows you to bring a tort claim against them. Tort law is a specific area where there are either common law principles or specific statutes that grant a particular set of plaintiffs a particular set of rights, and that they're normally court against regular people. So you can sue the individual people that are involved in the government, and they have a limited immunity, but you have to be able to prove that they were functioning outside their legitimate claims to authority as a government official, or you can bring an action against the government itself. But there aren't normal tort claims that can go up against the government. For example, if a federal postal delivery person is driving the truck along and runs over somebody's child in the street, you could file a lawsuit against the federal government under the Federal Tort Claims Act. That individual is liable for the normal things that any normal person would be able for, but the government has to pay it. If the government, like the CEA, Operations Directorate, is engaged in a covert operation, even though it's illegal under the National Security Act of 1947, a subsequent question is raised as whether an average citizen has the right to file a claim. Whether or not they have standing to actually file a claim under the National Security Act. Does a member of Congress have to bring the action? Who can bring the action? So you don't want to get too complicated about it, but the challenge here is, for example, in the Iran-Contra case, we filed an action under the Federal Criminal Racketeering Act. We put it out that we only sued the private individuals who were working in the off-the-shelf enterprise, and we did not sue any other government officials. We didn't sue Colonel Oliver North. We didn't sue Bill Casey. We didn't sue Donald P. Gregg, who was the National Security Advisor for Vice President Bush. We didn't sue Admiral Poindexter, who was the National Security Advisor to the President. And we didn't sue the President himself or the Vice President. Who we sued, for example, Theodore Shackley, who was the ADO. He was the Associate Deputy Director for Operations. That is the head of the covert operations for the CIA under George Bush, when he was the director of the CIA back in 75, 76, and 77. But he was retired now, so we can sue him in his private capacity. We have to understand that there is a big wall of immunity that the federal government has lifted up and raised to block people from being able to sue the government or sue their employees as long as they're functioning within the course of their businesses. So we have to be very creative about how to deal with this. And also bring an example of a writ de mandamus. There's another federal procedure that you can bring to federal court, where you ask a judicial officer, a federal district court judge, to intervene and issue a written mandate commanding that a given government official undertake a specific action which they are mandated by law to undertake. The problem is that they keep on asserting that they have a certain degree of discretion, whether they're going to enforce particular laws or not. The judicial branch grants great leeway to the executive branch to allow them the discretion to decide to what extent to enforce the laws or not. Lou and I have obviously been having some conversation about this and what we're going to do first and just discussed earlier today. What we're doing is we're understanding who our allies are, who our allies within the government, inside the Defense Department, inside the Justice Department, inside the Congress. We're all the allies who all agree with us that this activity on a part of a certain element inside the Defense Department is lying to the American public about the information they had regarding the UAP phenomenon. Not only that, but taking steps to punish people who are either inside the government or even outside the government, regular citizens who attempt to report these kinds of contacts with the UFOs. Will, in fact, a court entertain a petition for the insurance for a writ of mandamus, commanding them to obey the law, commanding them to obey the Constitution? Now, there's a point in time where you can be somewhat more creative with the federal courts and saying, look, this is a violation of the right of the people to know. For example, there have been over 260 federal judges who've been appointed during the term of President Trump, who've been based on the second term of Barack Obama, that they were all members of the Federal Society. I didn't know who the Federal Society is, so I looked them up. The Federalist Society for Law and Public Policy Studies, more frequently called the Federalist Society, is an American organization of conservatives and libertarians that advocate for the textualist and organist interpretation of the United States Constitution. The Federal Society is a group of lawyers and scholars who take an extraordinary narrow view of the Constitution. Texts don't believe that the judicial branch ought to be interfering with very great extent with the discretion of the executive branch. So what we have to do now is look at who the different judges are at a given point in time and a given court, and whether or not they personally will be willing to entertain a motion for the writ of mandate. There's a new thing that we've been exploring. There's a federal statute passed by Congress that says if a group of citizens or a group of citizens crafts a complaint and sends it to the United States Attorney's Office, that there's a criminal activity going on, that the United States Attorney shall present that complaint to the grand jury and allow the grand jury to review it. The problem is that you can't get a private attorney in front of a grand jury to assist the grand jury in exploring what the nature of the complaint is. The judge will normally go directly to the U.S. Attorney and say, okay, well, the U.S. Attorney, even if they're ordered to hand over the complaint to the grand jury, the U.S. Attorney is one who ends up deciding what he's going to say to the grand jury and what arguments he's going to make to the grand jury. The problem is the U.S. Attorney are all political appointees, so that the decisions are being made based on politics and the political realities of the moment as they perceive them, which usually has to do with a potential future advancement in the legal system. So that the decisions are being made based on politics and that the political realities of the moment as they perceive them, which usually has to do with potential future advancement in the legal system. And so that we're in a period of time with regard to our federal court system where one has to be extremely wise about what it is you accuse the government officials of doing. A political community which includes, in our case, the vast majority of the people, the regular citizens of the United States, who believe that we have the right to know this. This is extraordinarily important. This is probably the most important public policy issue that has ever confronted our human family. We, in a democratic society, have the right to participate in making those judgments. The challenge that we have here since 1947 is the passage of the National Security Act. A lot of people in the intelligence community and the defense establishment believe we're operating under the aegis of a national security state. So they keep tossing up in front of any kind of attempt on the part of the citizens to find something out, but saying that this is a national security or it's unclassified or it's secret in some way. So the minute that they invoke that particular nomenclature, the judicial branch tends to lock down saying, whoa, this is national security.
What in the wide, wide world of sports is going on here?
If the Justice Department or the Defense Department or some other government agency inserts this is a national security matter, we're going to defer to their judgment. And Thomas asked, Does that mean they have unfettered ability to take anything and lock up the information? Danny replies, well, that's one of the challenges. As Lou can share with you, and Sean and others can share with you, that the fact is that there has been the policy. The bottom line is Lou and I and other number of people inside the intelligence community, inside the Defense Department, who realize policy decisions about all of this, trying to figure out what the various means and the legal means that we have at our disposal. Together, this information communicated to the people so the people can make policy decisions about what we should be doing about this, because this is going to be affecting our relationship potentially depending upon what is behind this phenomenon. It could be affecting our relationship for the next 10,000 years with an extraterrestrial civilization, or conceivably some civilization that exists in some other dimension, or conceivably exists in some other time zone. Some temperate exact time zone different than our own. There are some extraordinary issues that are at play beneath this issue. We have to figure out what they are. Now, Lou Elizondo is in a unique position, along with a very few other people in the world that are in a position to help on this. That's why it's so important for everyone to protect Lou, to keep him from being assaulted by all those other elements that want to keep this information silent. That's one great value of a show like this. We can come and talk directly to the American people. It will help mobilize the American people who put the kind of pressure onto our government institutions to do the right thing in this case. Response from Danny Sheehan in Thomas Fessler's interview to be extraordinary. There's a lot to unpack here, but I'm just going to give you my 2 cents right now. Even though the older I get and the more sarcastic I become, I do find myself using more and more analogies to prove my point. But this is what I took from this interview. Like any game, you must first know the rules of the game. You must look through the battlefield and know who your enemies are and those who are your allies. It looks like Lou Elizondo found his general for his army, who has mastered those rules of this game. It seems as if everything is falling in place at the right time with the right people to win the game. All right, folks, I hope you enjoyed another edition of Military Witnesses to UAP. I'm Shannon Scott. If you haven't done so, hit that like and share and subscribe to my channel. Until then, good night, folks.